According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah.
Maybe it's wrong.
Yeah, it is.
An AI chatbot?
That's what the case law states, Mr. Alexander. If you didn't read the case law and you relied on artificial intelligence to provide it to you, then that's your problem.
Excuse me, Your Honor?
You heard me. This is the ChatGPT motion.
May it please the court. I come here today a humble pro se
All right.
before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
That is not a real person.
If there are no more questions?
So before you sit down,
Yes,
there's
sir.
one more thing I need to ask you about, unfortunately. In reviewing the trial court's order denying the motion for new trial, there are at least 5 citations to cases that don't exist. And there's at least 5 more citations to cases that do not support the proposition for which they're cited, including 3 quotations that don't exist. My understanding is that you prepared the order for new trial, the denial order for the trial court. Were those citations in the version of the order that you submitted to the trial court?
No, Your Honor, I do not believe so. They were not. I did prepare an order. That order was revised.
So those non-existent cases were cited in your initial brief opposing the motion for new trial.
Your Honor, I'm not aware of that, but I would be glad to research that and provide the court with a supplement.
Okay, we'll get a briefing order out directing what you need to supplement with. Okay, thank you.
I've got on my docket here is a motion for reconsideration of a defendant's motion for summary judgment from a while back, and then motion for sanctions due to some case law citation and other things that I guess the defendant wants to talk about. So,
yes, Your Honor. Andrew Willard for the defendants. As I stated earlier, I represent both defendants, the Victoria Glen HOA and his former president, Robert Cruz. The plaintiff, Mr. Pacheco. Essentially, Mr. Pacheco is arguing that he's being incorrectly assessed his HOA fees by the HOA, and this is resulting in him being overcharged compared to some of the other residents. The motion for sanctions, I'd planned on getting into a really descriptive explanation of what happened. However, plaintiff has filed a response to our motion for sanctions, I believe on Tuesday, or perhaps it was yesterday. In that response, just to summarize, counsel basically admitted his conduct, fell on his sword, and has addressed the issues, agreeing that there were false and fictitious citations. So in plaintiff's original response to our summary judgment, he cited to a single case for multiple propositions of law, about 6 different propositions of law supporting his arguments. And he even pulled a direct quote from that case. On my screen, that case is In re Christopher Kapmeyer. It's a 1-page opinion, but it does not contain a single one of the propositions of law that plaintiff relied on. Giving plaintiff counsel the benefit of the doubt, we searched for another case called In re Kapmeyer. We were able to locate it. There is a Supreme Court case with that name. The recorder and other identifying information is not what was cited in the motion, in the response. And this other In re Kapmeyer case only deals with, it's a joinder issue and does not contain any of the legal authority. So a week prior to the summary judgment hearing, we sent counsel a letter, which is Exhibit C, which I'm showing you, just explaining that, we were unable to find it. We think that, the citations are incorrect. And we asked that he either send us a copy of the case, send us the correct citation, or resolve the issue. We never heard back. All we got was a second response to our summary judgment, completely removing all citations to Kapmeyer and then citing a host of new cases. And in the second response, again, there were multiple issues, fictitious citations, what we believe are AI hallucinogen cases. And there was at least 3 cases that we identified that either a direct quote was pulled from that does not exist. The recorder number took us to a case that is not the case that was cited. And then there was another quote that did not exist. However, in our opinion, the most concerning case was a case called MBM Financial Corp v. The Woodlands, which plaintiff cited to as a Texas Supreme Court case. Plaintiff at the hearing in front of Judge Burgess stated affirmatively to the judge that this case recognized an ongoing economic breach as giving rise to a recurring cause of action, essentially arguing that every time Mr. Pacheco was assessed, it either told or reset the statute of limitations. This case does not mention that. Counsel made the affirmative representation at the hearing that this case was Texas Supreme Court case law. It was controlling law. The reason that this case is so important, due to its miscitation, and in fact, that case really only stands for the proposition that attorney's fees can be awarded in addition to nominal damages or something along those lines. So that doesn't even talk about this recurring violation rule, which again is not an actual Texas doctrine. But at that hearing, once this case was cited, I brought it up to Judge Burgess and said, Your Honor, I should have addressed this probably at the beginning of the hearing, but we believe the citations from this case are false, or there's hallucinogens or any of the hallmarks of generative AI being used. I don't think the judge understood the allegation that I was making, because his next question to me was essentially, well, do you have a Supreme Court case that rebuts that proposition of law? And then shortly after that, he denied our motion after we had a discussion about whether the continuing violation doctrine existed or not.
So, Judge, I want to address it directly. I put it in my response. The earlier filings did contain citations that I didn't verify properly. It shouldn't have happened, and I take responsibility for that. The issue is twofold, however. One is the citations may have been wrong, but the principle of law is correct, and that's addressed in the response to the MSJ on the merits. And the other issue is really whether this rises to the level of sanctions. I think the facts as described don't show conscious wrongdoing. I do believe that they show mistake or negligence. Chapter 10, similarly.
Mr. Lee, let me interrupt you for just a second. Did you use AI to come up with your response?
I did. I used several tools in order to do the research. The drafting that I draft by hand myself, but I do use available technology in order to do my work.
So you understand the obligation of counsel, if you're going to use or utilize AI, is to actually check the citations and the quotations that the AI provides.
Totally understand that, Judge.
If you were in federal court, what do you think would happen to you?
Judge, I can't quite say. I don't practice in federal court. I'm sure it wouldn't. I'm sure it would be as uncomfortable and difficult as it is right here today. At the time of the filing, I didn't independently verify that because it was such a truism that you can't have a summary judgment on
Don't start justifying using AI and hold on. Do not interrupt me, counsel. Do not attempt to come to me today and try to justify putting false information, false case law before the court, whether it's before me or Judge Burgess or anyone else. Don't do that. I just need to know
Understood.
The basis for even having this go on further, because the sanction issue is real. Okay? I'm definitely considering sanctions. I don't think it's appropriate that you come now today now saying, well, yeah, that was incorrect. I didn't do it right. That is a fundamental issue for lawyers. I mean, the public's trust in the justice system is that the lawyers will dutifully provide case information, court precedent, and cite it correctly.
Yes.
You understand that. And so it's very difficult for me to stand here today and listen to this and not think that the sanction should be very severe to you.
I understand,
you may continue,
Judge.
Okay?
Thank you, Judge. I'm not going to minimize it. I started out the conversation by saying I'm not going to minimize it, and I'm sorry that it came across that way. That was not my intent.
I'm going to do this. One, I'm going to vacate the prior summary judgment rejection by the court. I'm not striking pleadings. I'm going to order all attorney's fees incurred by the defendants to have their hearing on the motion for summary judgment, not the preparation of it, not the first one anyway. They're not going to need to be reimbursed for that, right? But I do need the attorney's fees incurred from the hearing date itself, because before that hearing, y'all gave him an opportunity to clean it up. So I'm not going to charge those fees or assess those fees, but the fees incurred for the hearing itself and the subsequent hearing prep for the hearing today, the instrument to file, and today's hearing, those fees need to be put into an affidavit. I'm going to award those fees, assuming they're reasonable and necessary. I'm going to have y'all have another rehearing on the motion for summary judgment. So we're going to reset it. I'm striking the response to the summary judgment that was filed by the plaintiff. I'm going to reprimand counsel, Mr. Lee, for utilizing AI and not actually researching any citations that were submitted to the court. For the response to the summary judgment motion, every single case you cite, sir, you shall include either a link to it electronically or the physical copy to both the opposing counsel and to the court. If you cite any case, they have to be provided.
Understood.
For this reply. And I want it highlighted. Hold on. And if you're going to do any quotations, they need to be in your response. They've got to be highlighted in the actual text of the case law. But don't ever do this again.
Yeah, Judge, never happen again. One thing that I do want to preview for you is, they're saying it's an orange. I'm saying it's an apple. They're claiming. Please stop it. Please stop. Just respond. I don't need to hear that now.
I guess let me hear from plaintiffs if you are still planning to proceed on your request for default.
Yes, Your Honor.
Okay. Did you receive the defendant's answers and affirmative defenses?
Yes, I did.
Okay. So then go ahead with your reasoning for requesting default.
Okay, Your Honor, defendants claim they lack proper notice under CR 55A3. Their own Exhibit 3 directly refutes that. It contains the June 20th email notice I sent. Due to the logistics of obtaining estimates and bids, I will need approximately 2 months to complete the damages evaluation. Thank you, Your Honor.
What are you reading from, Mr. Walton?
A thing that I prepared for this hearing.
Okay. How did you prepare it?
By putting everything together.
And how did you put everything together?
By reading all the documents, all the filings. I spent hours putting together dates. It took me probably about 3 hours to get this prepared. Make sure it was edited so it wasn't too long.
What sources did you use?
The documents and research, RCW 2.44, the court rules.
What type
I've been involved in numerous lawsuits, so I'm familiar with how to research and look up case law and things like that. But my position right now is that they are in default. They didn't file a valid answer. According to CR 11, every pleading must be signed by the attorney of record, and that simply didn't happen. Lawyers,
thank you, Mr. Yep, thank you, Mr. Walton. I appreciate it. All right, for defense, I don't know who wants to take the lead.
I will start, and then perhaps Mr. Conway can address the answer, the second answer. I mean, we're here, Your Honor, because for no good reason, right? As the court is astutely aware, the answer has been filed. It was filed on June 25th. Every other argument Mr. Walton has made to this court, presented to this court, violates CR 11, and reflects a profound misunderstanding of the rules. It is parties who appear in litigation, not lawyers. Parties appear, lawyers do it on behalf of parties. Once the party has appeared, they have to be given the notice. The fact that Mr. Volovovic or my office subsequently associated on behalf of these clients does not change the validity of the answers that have been filed. There is absolutely no legitimate reason we should be here. How Mr. Rosenberg and how those first cases that on the docket this afternoon, that's how this situation is supposed to be handled. The fact that Mr. Walton has ChatGPT or may have ChatGPT and has read it and doesn't understand the rules isn't a defense here. There is no good reason why my client should have had to pay to be at this hearing. The answer was filed by an attorney of record back the day after he filed his motion. Had he sent an email and provided the notice before filing the motion saying, hey, if you don't give me your answer, I'm going to file a motion for default, we would have said, oh, geez, here's the answer. So instead he files the motion. We say, hey, here's your answer. Please strike your motion. And then we get these meritless arguments that reflect a profound misunderstanding of the rules. The court is well aware he is supposed to be held to the same standard as an attorney. The fact that he is pro se doesn't excuse this. I gave him plenty of warning that I would be asking for sanctions if he didn't strike this here. And he has refused. He should be sanctioned. This type of behavior should not be tolerated. None of us need to be here right now.
Mr. Conway, go ahead.
Yes, Your Honor, nothing too much to add. We have, and I know that this is probably the first the court has heard on this, but there has been a long, tiring history of AI, appeared to be AI-generated motions and responses and challenges to everything. And most of what we do is met with, threats of CR11 sanctions. And we did get the answer in, and Mr. Mooney did, and I think he included the emails, but he did remind Mr. Walton several times of the rules here and how much it would cost us to come in and sit on this docket. I've now been here almost an hour.
Mr. Walton, anything briefly further that you want me to know?
Yes, Your Honor. As far as their arguments, I mean, the rules are the rules. I don't know why they keep misstating the rules. I'm not required to serve them notice before filing a motion. I mean, the plain language says 5 days before the hearing, so I don't know where that's even coming from. But first, CR 55A3 notice was fully satisfied. Their own Exhibit 3 shows that my June 20 email with the motion, blah, 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 was received, given 25 days notice. Second, appearance is undisputed. Mr. Conway appeared for all defendants on April 13th and never withdrew. No other attorney filed a notice of appearance. A notice of association is not the same as a notice of appearance. It's right there in the rules. It's pretty basic. Third, none of the answers are valid under CR 11 or RCW 2.44 because none bear Mr. Conway's signature. Finally, no valid answer to the First Amendment complaint was filed by the June 11th deadline. These arguments about that I'm required because other attorneys withdrew their motion and all this nonsense about frivolous misunderstanding the rules. I know how to read, Your Honor. Apparently, I don't know why they are. It seems to be purposely misleading, trying to mislead the court.
Okay. So
regardless of today's arguments, the procedural posture is unchanged. Notice was proper. Appearances are clear. Signatures are missing, and no valid answer exists. Default is appropriate. And I find it very insulting, this AI stuff. He's accusing me that I didn't write this stuff when I did. If you look through my whole history with this court, I mean, before AI was even a thing, you can see that I'm consistent. I read the rules, I read the law, and, except for right now being accused of what they're accusing me of, it's kind of frustrating. But with that, I'll leave it to the court. Thank you.
Yeah, so the reason that I called this case at the time that I did, Mr. Walton, was that I was hopeful that you would see the other cases that were on for default that frankly were in very similar position, and actually probably a worse off position than yours because there was an answer filed and then by one attorney and then there's an answer filed by another after notices of association of counsel. And case law is very clear that if you show up to this hearing, you're requesting default and an answer has been filed, the court's going to deny it. So I am denying your motion for default. It is not grounded in the facts of this case. There are proper answers that have been filed to the amended complaint. So I'm having a hard time following your logic as to trying to parse out who signed what when by all accounts, the attorneys, when they filed their answers, have indicated who their clients are. So there's simply no grounds for default. Again, the reason I called this case when I did was I was hopeful that when I came to you, Mr. Walton, you would acknowledge to the court that answers have been filed and you were striking this request. Because that hasn't happened, I am required to deny your request. And I am going to grant CR 11 sanctions for the attorneys having to be here and argue against default.
Okay.
This filing was a serious mistake. My clients apologized to the court, to opposing counsel and their clients, and certainly to their own client. They are embarrassed about this. They are disappointed in themselves and in the failure of their normal process that led to the filing of this petition. I don't know how much you want to hear from me up front, but I'd like to explain what we think happened here and what the firm has done to measures it's taken to make sure it doesn't happen again. And if I may, I'd like to add a little bit of background about Mr. Trevino and Mr. Bednar that leads up to the filing of the petition. What happened here was that Richard asked a law clerk in their office to prepare the initial draft of this petition. Richard then did some work on it, and he and the law clerk exchanged drafts back and forth as those things go. And ultimately it was filed. He did ask that those case citations be checked and later learned that didn't happen. But Richard did not do that himself. He does not point fingers at others. I'm simply trying to add context. He takes responsibility for this. He is the licensed lawyer who signed the petition and it was filed with the court.
So do I infer then that it was the law clerk who used ChatGPT to generate some portion of the filing?
Yes, that's correct. That's correct.
Is the law clerk licensed to practice law?
No. No, and that's why I say Richard takes responsibility. He's the one who is licensed. They work together on the document, of course, but ultimately the lawyer who signs and files it is the one responsible. We all know that. And Richard's not trying to hide from that responsibility today. I'm happy to...
Was Mr. Bednar aware that ChatGPT was being used to draft the petition?
No, he was not. And thank you for that question. I began by saying this was a serious mistake, and it was, but it was a mistake. It was not knowing. I don't believe it even satisfies the standard for recklessness. He did not know that AI had been used to generate anything in connection with the brief until after the fact, when they went back to try and reconstruct what had happened here, and then learned that yes, it had been.
And were there any conversations at any point prior to this brief being drafted about the use of AI in their practice and at their firm by this law clerk or any other employees?
To my knowledge, no. I don't think I've asked that specific question. But I've certainly asked that question about, going forward, and that AI was used. We acknowledge that in the generation, but I don't believe that Richard or Doug knew that in the drafting stage before it was filed.
And I'm asking more generally, did the firm have a policy, maybe something less formal than a policy for their employees about using AI or ChatGPT to generate work product?
I don't believe so. And I can stop to ask my clients specifically if you would like, but we've had a number of discussions and they haven't mentioned that to me, so I don't believe that was any kind of a policy. I can tell you there is a policy now, I think there is a place in the world for AI, but it certainly isn't the place to write your brief for you and find your cases for you. We acknowledge that.
Well, I don't think it's the position of the court that AI isn't a tool that can be used by lawyers and whatever assistance it may provide. I think the concern we have is obviously that in this case, ChatGPT hallucinated at least one case and probably cited other cases for propositions that were unrelated to those cases in their holdings. And a lawyer didn't check that, right? We as attorneys, as you've said, when we sign documents for filing with the court, we're making a representation under the rules about the veracity of the information contained in whatever the document is that we're filing, and that's a responsibility we bear. So while AI is certainly a tool that people appear to be using successfully, here it obviously was unsuccessful, and there apparently wasn't an effort made to double check it. And that's really the concern, I think, for this court, is that there was a failing on the role of the attorney to make sure that what was being presented to the court was in fact accurate.
Well, and the implication in my mind at least, the duty of candor to the tribunal.
Yes.
Here is this case, and it supports our position, and the case doesn't exist. That moves it in my mind beyond a mere error. An error would be it's the wrong pin site. We didn't realize the case was later overruled by the Utah Supreme Court. There are, I was going to say 1,000, that's an exaggeration. There are a bunch of cases in Utah called State versus Carter. Quite by accident, we cited the wrong State versus Carter. That's our error. It doesn't really support the proposition. But where you have a case that's non-existent and represent to the court by signature that this is valid authority, that's a more serious problem in my mind than a mere error.
Understood. I hear what you're saying, and I do think that the court needs to look at this as to what Mr. Bednar knew at the time the petition was filed. He did not know, and by imposition of duty, he should have known. We acknowledge that Royer versus Nelson is a non-existent case. It actually exists in Indiana as a table citation. There's no content to it. It is a fake citation, but it was never intended to be that way. And that's the point I emphasize today, is what was in the mind of Mr. Bednar at that moment. I will say, harking to a part of Rule 3.3, they have filed a request for leave to file an amended petition, in part, of course, to protect their client from the effects of this initial petition, but in part to correct the misstatements in the original one. That's one of the requirements in Rule 3.3, and they have done that. Now, what the court does with that request is not within the scope of my representation, but I point that out.
Nor really within the scope of the hearing, but we're mindful of the...
Yes.
Let me ask this, is the client, Mr. Gardner, aware of the order to show cause and order and the hearing that was set today?
Yes, and I believe he's here. Mr. Gardner is here.
Mr. Gardner, all right, thank you.
That has been disclosed to him fully. It was not a pleasant phone call for them to make to their client, as you might imagine. But they have been completely upfront with them since learning of this, and have tried to be the same with the court through our presentation today. And I had a conversation with Mr. Salen last week to attempt to accomplish that same purpose. I'm prepared to go through each of these citations if you want to drill down to that level.
I don't think so. We can do that.
But I will say, certainly the Royer versus Nelson case does not exist. The Westside Nursery and the Granite something construction case, they are real Utah cases, but they don't stand for the propositions for which they are cited. The Jones-Waldo case, I think, is appropriately represented in the petition. State versus Wilden, State versus Spry are also appropriately represented. They probably aren't on point ultimately, but I think as far as what's stated in the petition about those opinions, I believe that's correct. And I say that's my summary. I'm happy to address that further if you'd like. And I will say that I mentioned something earlier, but the firm has adopted a formal policy now about how they will handle the writing and the submission of any filing with the court, but in particular those that cite case law. I'm happy to walk through that with you, just a 4-step process, but I want you to know that that is something that they have done. It's a small firm, but it is a formal policy now. They don't ever want this to happen again. And an offer has been made. I know Mr. Salin and his clients have considered that. The offer is still open, and I think Greg and I can easily communicate about that more if they're interested. But the offer is to pay all of the legal expense incurred in responding to the initial petition. I suppose more if that is deemed to be warranted.
Well, what would be your position about a monetary sanction above and beyond making the other side's attorneys whole in view of the misrepresentation to the court? I know around the country we did a little research, and where this has come up before, this is not the first time it's happened in the country. This is happening all the damn time. Sanctions of $1,000 here, $5,000 there have been imposed by courts around the country, I guess, to sort of
make the point,
send the message more strongly than just making the other side whole would do. And I'd be interested in your position about the propriety of some such sanction in this case.
I think that's well within the scope of Rule 40 and what the court can do here. That's certainly not something my clients would love to hear, but they understand that that is a potential outcome of the hearing today. Rule 40, is it C or D? I've forgotten. That I think gives the court fairly broad discretion in imposing sanctions.
And obviously neither that sanction nor the attorney's fees to be paid to the other side, those wouldn't fall to the client. The attorneys would be responsible for that personally. I assume there's no issue on that.
They would be responsible for the attorney fees for sure. They would not charge their client for that. The attorneys would pay those attorney's fees, and I assume the same would be true if the court imposed a monetary sanction as well. I don't think any of that can be passed on to a client. Right. I guess I would. Sorry, Judge Oliver.
Yeah, I would just like to say, I think a concern I have in general, and this factors into at least my view of whether sanctions should be imposed and what amounts they should be, is that we had the benefit here of opposing counsel who pointed out to the court the use of citations that were hallucinations and didn't exist, and case citations that were incorrect as a proposition of law. We as a court system, as everyone knows, we're very busy. We have more work probably than we can do as quickly as we would prefer. And so it can't be that the judiciary is the backstop to double check and triple check every citation that's made in a filing that's presented to the court. We simply don't have the resources or the time to do that. And so what we do is we depend very much on the honor system of those attorneys who practice before us. And that is part of our rules, Rule 3.3, Rule 40, that when a document is presented to the court with a signature of a licensed attorney, that we can trust that what's being argued in there is being argued in good faith and based on real cases and case law, and is a valid and good argument for the extension of the law. And I think if this problem were to become more widespread, it's a larger problem for the judiciary and the integrity of the judicial system. And so I just want to say for the record that this is something that we have grave concern about, and something that we need to make sure that attorneys have grave concern about, and that they make every effort to make sure that what they present to this court under their signature is accurate to the best of their abilities. We certainly understand that errors may occur typographical errors, miscites and things of the nature that Judge Orm discussed. This is an entirely different category. And so that is why we called this hearing, which is quite unusual for the Court of Appeals to do. And so I say that just to explain why really we're here today. We take this matter very seriously on behalf of not only our court, but the entire Utah judiciary. And it's something that is very serious.
Absolutely. Thank you. And I confirm that my clients are committed to upholding the honor system that the court has just articulated. And they have learned that lesson in a very difficult way. And as I said, they come here embarrassed and disappointed and perhaps more firmly committed to make sure this never happens again than someone who hasn't been involved in.
Mass Mutual is being called out of turn, and the appellant has submitted a video for his argument. Okay, we will hear that video now.
May it please the court. I come here today a humble pro se before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
I generated that.
I'm sorry?
I generated that. That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes. Okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off. If you want to have oral argument time, you may stand up and give it to me. You have 5 minutes.
This is the City of Owasho's motion for summary disposition. I have read the motion and I have read the response. Mr. Gould, are you ready with your argument?
I am, Your Honor.
All right, you may step up and proceed.
Before I get into the actual legal argument, there's a few preliminary matters that I think have to be brought before this court, and they are very much related to this very summary disposition. City of Owasso filed a motion for summary disposition. Mr. Mead responded. Having researched Mr. Mead's answer to the summary disposition, it came to light after going in circles for some time that the case law cited, the opinions apparently rendered by some court, are in fact fictitious. I have reason to believe that AI probably helped Mr. Mead in this, and because I went round and round, second guessing myself about these case laws, about whether there were courts out there having these different opinions about municipal law, I finally had to reach out to a colleague who's also a municipal attorney, Justin English. I had him review the same cases, and with those cases, I have an affidavit from his office whereby he himself, using different tools of research than which that I have used, saying that these cases are in fact fictitious. I have an affidavit here by Mr. English, if the court's so inclined to.
Why didn't you file a reply and include it in a reply, Mr. Gould?
Well, Your Honor, I will say that as I kept researching this matter, I for lack of my own confidence, I thought I was missing something. I kept chasing ghosts out there. And
that's why they call them hallucinations.
Yeah.
Right? Fake cases, fake AI cases are called hallucinations.
Well, the actual name, okay.
Yeah, that's what they call them. They call them hallucinations. Oh, I'm well aware. I've done the same thing you have. It's pretty unsettling, isn't it?
It is. It's concerning, and Owasso's my hometown, and it bothers me that, you know, this is serious stuff. This is an expense to the taxpayers. I mean, I'm not trying to talk myself out of a job, but making allegations and then coming to this court with fictitious court names and opinions dangerous in a lot of ways, and it's concerning. So,
okay, so the issues of material fact, that's probably the most important one to go with.
Actually, it's kind of important. My mind is this deal with these cases. Much like Mr. Gould, I spent a lot of time looking at the cases that you cited, and I can't find that these cases exist. Where'd you get these cases that you cited?
Google and a lot of AI research.
You used AI, didn't you?
I will freely admit it for the research. I'm not trying to waste your time.
You didn't check and make sure that those are real cases, did you?
Not on every one of them, unfortunately.
So that's very bad, Mr. Mead. Because when you cite a case that isn't good law, you're misrepresenting the law, not only to Mr. Gould, but to the court.
Understood.
When you cite a case, you're telling the world, look, this is the law that you need to follow, Judge Stewart. This is what I'm representing. And then when it's not, it's a misrepresentation.
It's only the misrepresentation that I was under the impression of also.
I don't understand that.
I was led to the impression that was, I should have checked. I freely admit, I apologize for that.
Okay.
I did my best to check on as many of those as I could, but my time is limited.
So because your time is limited, Mr. Gould and then this court had spent a lot of time trying to verify your cases.
So
whose time is limited, yours or ours? I mean, we spent a lot of time looking at the 5 cases that you cited, and you said you didn't have time to check them, to verify them, right?
I'm not saying that at all.
That's what you said. You said my time was limited. That's kind of disrespectful. Your time was limited, so you didn't check your sites and shifted the burden to the court and to Mr. Gould's office to determine the accuracy of your sites.
It's very disrespectful of me to do that, but I assure you that was not my intention. My intention was to relay what I had assumed was accurate information on the basis of the amount of checking that I had done of the citations previous to that. So it's not that every response from an artificial intelligence agent is completely hallucination. There's a mixture of accurate information, real citations.
And if you know that, that's even more troubling to me. You know that there's hallucinations out there and you didn't double check your sites.
Your Honor, for these proceedings, I'm somewhat overcome by the requirements of the paperwork and the amount of research that has been required.
No, you said you intentionally included a legal site, a case site, that you knew might have been a hallucination.
No, sir.
You just said, I know that some in AI, some of it's accurate, some of it's hallucinations.
Allow me to clarify.
But that's what you said.
I'm aware that it's possible that they could get through, but my intention...
So knowing that, you didn't check and make sure the site was legit?
I thought I had checked every reference that had gotten through 2 submissions to the
So
court.
you just happened to not check the 5 cases that you cited?
Your Honor, that was 5 cases in a volume of probably 30 or 40 cases that I was also researching.
But you cited 1, 2, 3, 4. You cited 4 cases at the beginning of your answer, and you laid them all out in the middle in bullet points. And you said, my time is limited. I checked some of them, but yet you led your brief with these 5 cases.
And Your Honor, this is my first ever legal case. I apologize.
This doesn't have anything to do with the legal case. This is lying. This doesn't have anything to do with being a lawyer or being a non-lawyer. This is putting a case out there for the court and representing to the court that it's true and it's accurate. That has nothing to do with being a lawyer.
Your Honor, I put nothing in there that I knew to be misrepresentation.
But you did, because you just said sometimes that AI can give you inaccurate results. You're just digging yourself in a hole. You better continue with your argument then.
Accounting for the presence of...
It's surprising in this case because plaintiff's brief contains a fair bit of material that really demands a reply. It looks like Mr. Gould is working on it and has actually had another attorney assisting him with it. Much of the case law in plaintiff's brief is fabricated, or what we refer to as an AI hallucination. Plaintiff cites 4 cases on the second page of his brief and provides what he claims to be direct quotes from those cases. First, 313 Mishap 104, he claims it's a 2015 case. Plaintiff identifies this as Bingham Farms versus Lawrence. But if you go to that site, it actually takes you to MEEMIC versus Michigan Millers Mutual Insurance. Plaintiff specifically cited at page 116 of that opinion, which is actually from a case called Chiropractors Rehabilitation Group versus State Farm. And there is a Bingham Farms. We found it, and that case didn't involve chickens, but it involved sewers and waters. Municipalities arguing over access to sewers and waters. Plaintiff's next cites to a case that he calls Hatfield versus Township of Heartland, a 221 case identified as a Court of Appeals docket number 354103. That docket number points to a case called In Re BS. I'm not pointing out the irony of this name in the bench opinion, but that's an adoption case, and it's unsurprisingly silent on the issue of keeping of chickens. The next case cited by plaintiff, Farms Not Factories versus the City of Lansing. Court of Appeals docket 367891. But that docket number belongs to a case called Henry H. McClinton, another adoption matter. Here's another case, Adams versus City of Battle Creek. For this case, plaintiff provided a bogus Westlaw citation that doesn't return any case at all. In fact, Westlaw citations are 7-digit citation numbers, and this was 1, 2, 3, 4, 5, 6, 7. The odds of a case with a citation of 1, 2, 3, 4, 5, 6, 7 is 1 in millions. I've never seen in my career as a judge and attorney seen more than 3 sequential numbers in a case cite, let alone 7. The court found a 2001 wiretapping case by that name, but it has no bearing on this matter. He also cites to Williamstown versus Sandalwood Ranch, 325 Mishap 541. That's a 2018 case. The citation checks out, but that case involves latches applied against a plaintiff municipality. Defendant corporation asserted an affirmative defense of latches, and the Court of Appeals held that the corporation failed to produce evidence to substantiate the defense. Next, plaintiff cites 478 Mish 908, claiming it is Papadelis, Papadelis versus City of Troy. That citation could point to short orders on 2 other cases, neither of which are consistent with plaintiff's brief. The reason why I spent so much time talking about these hallucinations is that I spent a lot of time trying to hunt down the law. Apparently, Mr. Gould did too. It's incredibly inconvenient when the attorneys and judges and court staff are trying to make sure we get it right by finding the correct law. And this wasn't that. And by signing your answer to the motion, Mr. Mead, you certified that your response was warranted by existing law, pursuant to MCR 1.109E5. The court isn't going to sanction you today. The court is just going to admonish you for misrepresenting the law. And I'll leave the issue of attorney fees to Mr. Gould. If he wants to file a separate motion for attorney fees and lay out what you've done and what your position is and based on the law, I'll consider it, but I'm just not going to do it today. But what the court is going to do is strike the plaintiff's answer in the offending brief. And I think that's a fair remedy. I'm just striking it. That means that the court will treat the motion as though no response has been filed. That said, even if the court does consider the brief, even if it did, the plaintiff would not prevail at the motion hearing. Plaintiff argues that genuine issues of material fact preclude granting the motion, but plaintiff didn't attach any documentary evidence in support of his position, meaning he can't and didn't show a genuine issue for trial. Plaintiff's response also did not address the C8 components of defendant's motion. So that aspect of the motion is truly unopposed, at least on the papers. So for all those reasons, the motion for summary disposition based on C8 and C10 is granted, and this case is dismissed. Mr. Gould, please prepare an order, and I'll leave it to you if you want a remedy on the AI.
I appreciate it, Your Honor. Thank you.
Thank you all. We're in recess.
Your documents, your your motion, some of the cases weren't making sense.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to...
I did, Your Honor, and that was something that I wanted to bring up today. So I was
that's part of the reason why I didn't file a reply, is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name. And
neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure. I'm pulling it up right now, Judge. Bear with me 1 sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Just hold on 1 second. I'm trying to actually pull up the case itself. Hold on. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193, 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name, or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case at 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company, I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. And that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersion. I'm just telling you, so he's been suspended in Maryland, and part of that was for lack of candor.
Hold on. Where is he?
It appears that he either dropped off the Zoom call or lost internet connection.
I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr.
Please.
Gillespie, I'm a former
Yeah.
staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess Chat GPT or whatever the legal version of the AI, research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than happy to provide additional briefing, copies of the cited cases, whatever.
Well, I trust that
like.
Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if 2 lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good then. Should we? How would you propose we proceed?
I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that. I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct?
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to, I guess, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
Playing from Tristan's iPhone.
All right, don't know what that was.
Go ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And, we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further, but I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say.
What I do have is a desire to make Mr. Kennedy's clients whole in as much as he's had to respond to these motions. He's had to spend court time. He's had to spend office time. He's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I'm so old school that this is the phrase that keeps coming to my head: garbage in, garbage out, which we were all told when at the outset of, and I'm old enough to go back to when we switched from typewriters to personal computers and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston-Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston-Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am, and then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file, if you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one. It's just kind of a math question. I just want to know if it's fictional or a fact.
Math is usually not fiction.
Yeah.
It's math.
And yeah, so I'd just like to be explained, like how the math works. So I'm pretty good at math.
You want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honest, we go to law school, so we don't have to do math. But we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
I think it's great. The issue, and it's been up with Ms. Anderson, is he had a question about the grams per 100 milliliters.
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
yeah.
Maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
It's just that I was measured in thousands, and the law goes by hundreds.
We can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do and have a lab analyst up here to explain? all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce
and yet you blew a .221 allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late. Okay. You're not supposed to be late to court. Okay. You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating
I'm just
science.
saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a 10th. 2 numerals behind the decimal is 100th.
Yep.
3 numerals behind the decimal is 1,000th.
Yep. I know math.
Okay. And 1,000th is 10 times less than 100th.
Well, let's cut that off. Okay. You blew a .22 with a PBT.
221.
Or .221. Okay. So let's say you will cut off the 1 because that's what math does. You get to cut off certain things. So you were .22. We'll give you the benefit of the doubt. No more with that 1, that 1,000th, gone. So you blew a .22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. 0.19. It's .08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000th is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's .22. It's .22.
No, if there's 3 numerals, because if it was
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra 1,000th in the decimal point?
It's not an extra 1,000th, though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just so give me the knowledge because I like math. And
here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and giving extensions. You're fair. And I'm here. And I'll go to jail. Get out. I got a job.
All right. So are you admitting that you at least blew over a .08 or at least .08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221, and I agreed that my blood alcohol was at 0.190.
Okay, all right.
I agree with those.
And so, and do you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right, Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten to hurt you or anything?
None of those.
Okay. You're pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily?
Yes.
Does anyone or are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate
okay.
time, okay? This
Okay.
isn't a time to conversate.
Okay.
This is a plea and sentencing
Okay.
in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right, because he's not a scientist, but he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keen, you said that's not a defense, correct?
And yes, and we have discussed that in basic math and other things along with it extensively.
All right. Okay. You have any? No. All right. So based on this, the OWI third, count 1, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a 0.19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP. But he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked in a release, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on a third offense, which I believe is $1,911 for fines and costs. It's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keen.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to, deal with the harm to community. Although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. He also, as with an OWI 3, he would have a blood alcohol content restriction of 0.02, which means, I'd be careful about even non-alcohol alcohol, because 0.02 is nothing for the next 2 years. And it does have the future deterrence because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin state prison system, because OWI-3 is the last one, it's still considered a misdemeanor. So I think that although it was a painful process to get here, the court should stick with the agreement because, you know, it a pain, but Mr. Lamprecht has met the terms of the IDIP, albeit not in the normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI-3 and the ignition interlock provides that for 2 years, plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the, less than beneficial behaviors at times exhibited by Mr. Lamprecht.
Thank you. Mr. Lamprecht, anything you want to add or say to the court?
Nothing that I haven't already.
Well, I mean, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law, I ensure that that the community is protected in certain ways. OWI is again serious. You're putting yourself at risk, you're putting others at risk. The fact that you blew a .221 had blood alcohol content from blood at 0.19 is serious, especially given
190. Sorry for interrupting.
Don't interrupt me again. You interrupt me again and I will hold you in contempt. I will hold you in contempt and I will ensure that you have more jail time than what's being sentenced here today. All right?
I like you and you're a fair judge. I'm not trying to piss you off at all.
Then stop talking. Okay. I need to ensure that the public is going to be protected. And that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again. What I will do is I will follow the IDIP guidelines. Despite all of the issues in this case, I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it or the interlock in it, or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. If you wish to convert the 75 hours to additional jail time, you can do so. Talk to Ms. Anderson. She will ensure that the court gets a letter and you must pay every, it's an additional 8 hours of community service for 1 day of jail time. So it's an additional $18 a day that you would need to pay if you wish to convert any community service to additional jail time. You must report immediately report to jail. And that means that you will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must sit in jail. You don't get additional time. This is where I'm very serious. You blow even a 0.0000001 with anything with alcohol, 0.00001. That's a violation to me. You will be immediately terminated off of the monitor. You will immediately report to jail, and you will sit the whole sentence. No good time, no Huber. I was near rubbing alcohol. I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Okay? I take no excuse. It is an immediate report, no good time, no Huber. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, a civil judgment will be entered against you. You will also need to, you could sit up to 6 months in jail for that. I make sure that the money is paid. If it's not paid, it may result in an additional 6 months of incarceration. So ensure that you make your payments. When are you going to pay off the entire $1,921?
I have enough for the monitoring and the jail fee at this time.
$150 a month you must start paying. I'll give you August 1st. I'll give you a little stay until August 1st, but then in August, you must make your first payment at $150 a month until that's paid off in full. Again, if you miss one payment, a warrant will be issued. You could sit up to 6 months in jail. It's very important that you make sure you pay. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Report to jail immediately. Your DNA is ordered. They will take that. You can request it be expunged through a written letter to the Department of Justice. Mr. Renicky, what am I missing?
I think you've covered it. Thank you.
Mr. Keen.
You're not on that, but I did have a couple of items. One is, and which didn't get filled out, if he has the opportunity while he's sitting to fill out the petition for half-price ignition air lock, if he qualifies, can he submit that to the court?
He can. I'm not going to give him time to do it. He's going to go report to jail.
Right. Understood that. Understand. And then the other item is one I filed way back in October, and you at the time rejected the proposed order and so could you
to waive fines and fees?
Well, it's to reduce the fees by the amount paid for the IDI, the alcohol assessment and the driver safety plan if they're provided to the court. And the 10th Judicial District, I will admit it varies by court. Like Douglas County does it, Barron has it.
Want me to waive?
What it would be is like, he has that fine of 1,900 and some bucks. What the statute allows is, if the court grants it, is to have the amount of the fine reduced by Mr. Lampick providing receipts to the court for the assessment and driver safety plan.
No,
okay.
I don't do that. And so you can understand there's not much that can be waived. There's a lot of mandatory surcharges in there. And when you go through it, really, because I've had really poor people that have asked, can I just do community service with the ones that cannot be waived? There's not really that many that can be waived. And plus, this is a punishment. That's part of the punishment. And so I see it as a punishment. And that's why the legislature has increased, and they continue to increase these fines and fees. It's to say, don't do it again. Don't do it again. Don't do it again. And so, no, I'm denying that motion.
Yes, sir.
Thank you. Ms. Atkinson. Ensure that he gets and reports to jail immediately. You may.
Can I make a couple phone calls?
That's up to the jail.
Yeah.
Good morning.
Okay, any pretrial motions to take up?
I have a couple different pending motions. Motion for discovery. I had submitted a request for discovery. I also have 2 motions to dismiss. In this case, there were 3 cause numbers. They've kind of been put into the same case. So I'd like to make the court
Let's take up your argument on the first one, which is the notice of pending motions for discovery. Go ahead.
Okay, so you'd like to start with discovery, sir?
Yep.
Okay, we submitted a request for discovery and a full motion for discovery. We have yet to receive anything from prosecution regarding said motions.
You haven't received a date and a time to go review discovery?
Excuse me?
You had not received a date and a time to go review discovery at the prosecutor's office?
No, I did not.
Your Honor, that is untrue. In fact, my assistant, Jennifer Rodriguez, held a discovery conference with the defendant on January 13th, 2026 at 10 a.m. He, however, refused to sign the joint discovery statement.
Yes, Your Honor. At that time, somebody from her office, after I asked for identification, I asked if she was either with the clerk's office or prosecution.
What difference does that make?
It's because I also turned in a PIR request asking for document.
What difference is the fact that she didn't identify herself as a clerk or assistant? What difference does that make with discovery? You're here to argue a motion for discovery.
You're right, Your Honor.
Okay, so you got your opportunity to go and review discovery. What didn't you get?
I didn't get any of the breadth of what was asked for in our request for discovery.
If you didn't get it, they can't use it.
But they're tantamount to my defenses, sir.
If they didn't give it to you, they can't use it.
I received 3 case files from the prosecutor. In one case was the claimant letter, and when they gave me the 3 case files, in one of the case files was the claimant letter and a copy of the citation. The other one was a claimant letter, copy of the citation, and a photo of the front of the Flying Walrus. In the third file was roughly the same.
So you got discovery?
No, sir. At that point, I asked if I could have email correspondence and that if they could send it to me in email, or that if I would be allowed the opportunity to take pictures of what was in the file. Neither was allowed to me. I was then provided with a pen and a paper and told to take notes.
Why are they required to provide you with pen and paper? Why didn't you go prepared with pen and paper?
No, because I was not alerted that I would be talked to at that moment. I was caught as I was exiting another case. I was here for another case. As I was leaving, young lady stopped me in the hall. At this point,
you had an appointment for discovery. Did you go to that appointment?
I did not have an appointment for discovery.
The prosecutor just said they send you an email with a time and date for discovery.
She stopped me in the hall.
I know they stopped you in the hall, but you also got notice for a date and a time for discovery.
No, I have not.
You didn't get one. So
I did not receive it.
Raise your right hand. Raise your right hand. You swear and test to the fact that you're about to give to this court as true and correct?
To the best of my knowledge, true and correct. I was not provided an opportunity to come in for
I'll hold you in contempt, Mr. Alexander, if you're lying to the court.
I am not lying. To the best of my knowledge, I was not given to. I was stopped in the hall, Your Honor.
And why did you show up and review? Because you were stopped in the hallway?
Excuse me?
Why did you stop and review? How did you review this discovery? Because you were stopped in the hallway and you were told, come in and review right now?
Absolutely. That's exactly how that went. Your Honor, that's exactly how that went.
Does the state have a copy of the email that was sent to Mr. Alexander?
I'm looking at the email right now, Your Honor, but I do have a copy of the correspondence that was sent to Mr. Alexander dated the 23rd of December, 2025.
All I have from Your Honor was an objection from the prosecution.
I have the email, Your Honor.
What's your email address?
jamesra11778@gmail.com. If there is said email, I simply was not aware of it. Does the prosecution, I had no response to it. I was not aware of it.
The state can't help you in opening up your emails, Mr. Alexander. They met their obligation by sending you a date and a time to come review it. What do you want me to do? You want me to tell the state, now you got to call him, or you also got to go by his place of business or home and make sure, let him know that he got the email?
Yeah, Your Honor, honestly, in all fairness, I came into the office, presented both handwritten requests and motions, talked to him directly, sent emails, went above and beyond in my requests.
Okay, I understand that. But we're here for a motion for discovery. In other words, you're here indicating to the court that you didn't get discovery.
I have not received it, no, Your Honor. No, I have not.
But you reviewed the discovery.
I reviewed packets that did not cover the breadth of what was asked for in discovery.
Okay, what you asked for and what the prosecutor has are two different things. Okay, if you ask for videos and there's no video, then there's no video. And nobody can use a video if it comes up all of a sudden because they didn't provide you with a video.
Yes,
so
Your
if
Honor.
you ask for certain pictures or certain documents and they didn't provide them to you, then they don't exist. And if they do exist, they can't use them in trial.
I asked for email correspondence between those that were on the ground and anybody else within the office. They should have access.
What are you talking about, email correspondence?
There's officers working on the ground. Yes, Your
Okay.
Honor. And if through our motions to dismiss, there's at least tantamount to the defenses. I didn't want to get too much into like exactly what our defenses would be here. But there's at least some concern about why they were there, because ordinances are usually put in arbitrarily, or because there's been a complaint, or because there's been known hazard, or because there's some sort of permit violation that usually, in this case.
So there's no standard random inspections that can be conducted? Is that what you're arguing?
I would definitely argue that there was nothing random about these inspections.
I'm asking, can there be? I'm not asking whether yours was.
Yes, and
Okay.
I would be afforded the
Let's go back to the discovery
opportunity.
then. It seems to me that the state did everything they could to provide you with discovery. If there's no documents or certain things that you asked for that were not provided to you, then they can't be used at trial.
Well, then I would like to.
Let's
if
move
you
on.
can give me a moment, I would like to go through the rest of the things that I was also asking for that they should be able to have.
The rest of the what did you want?
I provided a very detailed list of things that I was
Again,
looking for.
if you didn't get it, nobody can use it. That's it. Just because you asked for it and they didn't give it to you doesn't mean it exists.
They are tantamount to the defenses I plan on raising.
What?
The defenses I plan on raising.
That's up to you. You have to establish your own defense. If you don't get the documents you use because your plan as to your defense isn't being worked out the way you wanted it to because the documents weren't provided by the prosecution, then that lies on you, not the prosecution.
I mean,
you have to change your plan or the way you're going to approach this because you don't have what it is you thought you were going to
I'm
get.
operating under the belief, Your Honor, I'm sorry, I apologize, but that I should at least get copies of the offense reports, any and all documents that were taken related to those reports, recordings, and any kind of electronic duplication. That's all stuff right under the Michael Morton Act.
You didn't get the opportunity to review those?
Your Honor, I'm telling you, what I was given was nothing more than the claimant letter.
Then
and a
that's
copy
all.
of the
Listen,
ticket.
you're not listening. You're hearing me, but you're not listening, right?
Your Honor, go ahead.
You got a copy of the claimant letter and the citation, right? Is that what you said?
Am I to believe that the
I'm
prosecution?
asking you a question. Is that all you got?
Yes.
Is that all you saw?
Yes.
Then that's all they can use.
If I may, Your Honor, the state would like to assure the court that we did give the defendant the opportunity to inspect everything that is under the control and possession of the state.
Right. And so whatever that was, that's all they can be used at trial. Just
Yeah.
because you didn't get what you asked for doesn't mean they're holding back on discovery. It means they don't have it. And if they don't have it, then nobody can use it at trial. If you want a video that doesn't exist, the video can't magically appear on the day of trial and the state say, well, now we want to. No, you didn't provide it to the defendant, so you can't use it either.
Your Honor, if you give me one moment, please.
And Your Honor, I'd like to take this opportunity, I'm sorry, Mr. Alexander.
Go ahead.
To respond to defendant's assertion that the state or the city cannot perform random inspections. Section 138-337 of the McAllen Court of Ordinances titled Enforcement, Notice of Revocation and Reconsideration. Subsection A states that the provisions of this division shall be administered and enforced by the Director of Planning, and there shall be the right to enter upon any premises at any reasonable time for the purposes of making inspection of buildings or premises.
At no point, Your Honor, did I make such assertion. There was no need for prosecution to defend herself on said
Okay, let's move on. Go ahead. What else?
Okay. I would just like to know for I'm leaning basically on Article 3914, Your Honor, and additional authorities cited to preserve the record at this time that
There's a record being done. Okay, we got a record going, so that's no problem with that.
For the record at this time, I would like to respectfully object that my full discovery needs were not met at this time by prosecution.
Okay, so noted. Go on.
Thank you, Your Honor. I appreciate the clarification at that time. I'd also like to note at this time that it is my contention that discovery should allow me the meaningful opportunity to prepare the defenses.
Mr. Alexander, this is going to be the last time I address discovery.
Discovery. Would you like to move? Would you like to move on, Your Honor? I'm sorry.
Would I like what?
I'm sorry if you were trying to move us on. I wasn't following. I apologize. I'm not trying to be adversarial.
Well, this is an adversarial hearing between you and the prosecutor, but not between you and the court. But I've already made my ruling on discovery. Discovery was provided. Whether or not you opened up your email is neither here nor there because the prosecution has met their obligation to send you notice. You did, by your own testimony, state that you did review discovery. You didn't get what you wanted. You didn't get everything you requested. And the court has made it very clear that because you did not get what you requested means it more than likely does not exist. And if it does exist, they can't use it at trial against you because they didn't provide it to you.
Then I would just like to note for the record, Your Honor, that I informed, I don't know the young lady's name that you sent from your office, Ms. Borrego? Ms. Rodriguez. I informed her that time after she handed me the joint discovery statement that I was not accepting that as a transfer of discovery. I made that very clear in that conversation. I let her know at that time that I did expect the rest of the discovery and the motion and the request to be addressed at that time. She noted said such. She even presented me again with the joint discovery statement and asked me at that time if I would be willing to sign it. I told her, no, it does not cover the breadth of what I was asking for. And while that I was willing in good faith to go under her instructions and write down on the notepad the notes of what I was provided, that I did not feel that discovery at that time had been completed.
Okay, let's go on.
Yes, Your Honor.
What else do you have to argue, Mr. Alexander?
We are also here for motions to dismiss, Your Honor. Your Honor, there are 3 cause numbers today. I have filed separate motions to dismiss in each case. They do have overlapping issues that I've raised, so I'm not against having them heard together, but of course, that's a decision for yourself.
For the basis of all 3, the same argument?
They overlap substantially.
What does that mean, they overlap? I don't understand what that means.
The main one is that all 3 involve cases that right now have been cured.
What does that mean again? I don't know what that means. Your cases have been cured. What does that mean?
Means that there is no violation for which full compliance has not been met.
Who concluded that?
Prosecution's aware.
Who concluded that it was already done with it?
The inspectors on site. The inspectors have come in and.
Right, but you requested a jury trial.
That was before.
No, sir. No, I recall. I was there when I administered that hearing to the owner of the building, and they offered you the same offer that they gave the owner of the building for a 0 fine and to plead and you just said, no, I want a jury trial. And that's why we're here.
Because I believe that full dismissal and in the interest of fairness and justice is really the only.
Then we're here for a jury trial. Let's go.
Yes, we are. At this time.
So they haven't been remedied. Let's go.
Excuse me, Your Honor?
They have not been remedied, Mr. Alexander. The day the citation was issued, the violations were in place. They're occurring. That's why the citation was issued. Yes. Whether or not they were remedied after the fact makes absolutely no difference.
They were cured in under 24 hours, Your Honor.
Was there a violation done when the citation was issued?
Yes.
Okay, then that's what we're here for.
As our motion to dismiss also carries out.
Your motion to dismiss will be denied based on the fact that at the time the citation was issued, there was a violation that occurred. Whether or not it was cured half an hour or an hour after the citation was issued is of no significance.
Your Honor, at this time, compliance was achieved. The purpose of the ordinance is compliance and safety.
Right, and at the time the citation was issued, neither one of them were in place, so you were issued a citation. Let's move on, Mr. Alexander. Your motion to dismiss is denied.
Then I would like to preserve at this time.
There's a record being made. Everything's being preserved.
Yes, Your Honor. I would also like to point out that we had a compliant history going back 14 years coming into this. We were never made aware.
What are you arguing now?
Estoppel and latches, Your Honor.
Okay.
In this case, not only had we had a compliant record going back 12 years, but I'm not here to argue that on the ordinance that said violation could not have occurred or that there wasn't one. I am contending that it was cured in under 24 hours. But what I'm also contending is that we had reaffirmation from the city over a 12-year period They continued to renew our permits. They continued to inspect. They had inspections in that time, many dozens over that years, and never at any point were we under any belief that we needed to do these things. If asked, we were willing to comply immediately. And again, that there's simply not a remedial purpose in these prosecutions. That the government, what the government or the city of McAllen has asked for has been complied with. And that we had always operated in good faith. And then in fact, in this point, we had operated in good faith. We had no reason to believe the two violations I am talking to about are a security light in the back alley. The city has, basically the city put in security lights all along the alley back in 2015 and 16. I don't have my phone with me because I'm not allowed, but I have hundreds of photos showing where the security lights themselves, none of them are operational. We were never asked. That's not a defense of our need to do it. It was in reliance on those security lights that we were never asked over a decade to provide any kind of lighting in the back. We simply were not. Our special use permit was renewed. It was first put in 2012. It was renewed again in 2015, renewed again in 2018, renewed again in 2021, and renewed again in 2024. In 4 different renewals, we were not asked for age verification devices, UV markers, or the lighting in question. As soon as we were asked, we complied in under 24 hours. This is noted by inspectors. This is noted by those on the ground. It's just, Your Honor, and it's in all fairness, we were rushed into court here. We
Rushed into court.
Yes, Your Honor.
This was back in April 16, 2025.
Which cause number are you talking to here? There are 3. I'm sorry, Your Honor.
It has this one for the selling of food without city permit. No, that was dismissed. So this is the building code permit, electrical work, and the construction without inspection.
There was no electrical work. We cleared that up, Your Honor.
Well, that's what I have here.
Yeah, there's been some confusion. And then in that one, the one building permit case, we were actually actively complying.
Okay, but let's go back and focus on your latches, your argument. Because
The argument there, Your Honor, is that we had operated for well over a decade.
And so you're claiming that the delay was unreasonable.
The delay,
Is that what you're saying?
if we were made aware that all of these things were necessary, we would have complied. We continued to have our permit renewed every 3 years. And so we were really just relying on their affirmation of that we were in compliance. Anything that we would have been asked when they asked us for another renewal.
Let me go back just a minute. What was the basis of the affirmation you made it?
Every time you resubmit for a permit, you're supposed to be.
What type of permit?
The special use permit. That's what they're holding the ordinances are. These are violations based on ordinances.
Okay, your argument is that every time a special use permit is issued, what?
They come through and make sure we are in compliance before issuing or reissuing the special use permit.
And in compliance with what?
With
everything built in, everything
built into the special use permit.
In response, Ms. Borrego?
Your Honor, in response to his general argument that the city should be stopped from enforcing this regulation, I'm going to go ahead and refer to a case that he himself cited in his motion to dismiss, which is City of Hutchins v. Krasivka. So I think what happened here is that he basically included cases that had keywords in there, but they don't necessarily apply. And in fact, this particular case states that the city or any governmental body cannot be stopped where there is interference with government functions. I would say that enforcing a city ordinance is a government function, and therefore the city cannot be stopped from doing so.
Oh, I'm not here, and at no point am I arguing that they can't enforce their ordinances.
I know, but you're citing that case.
I'm saying.
Hold on, let me finish. You're citing that case in support of your claim.
Well, then I'd have to pull up the original motion to dismiss and look at it, if you don't mind. She's pulling one case. There was
I would
several
assume you'd
cases.
have that with you.
Yes, I do. I have to pull it up.
And Your Honor, respectfully, the state would like to further assert that this argument of estoppel or latches is in furtherance of his motion to dismiss, and the court has already ruled on the motion to dismiss.
I'm sorry, Your Honor, is the prosecution contending that, because it's not our assertion whatsoever that you can't enforce your ordinances?
Of course it is. You cited it in the case to support your position.
No, Your
What do you
Honor.
mean, no? I'm looking at it right here. It's equitable estoppel and latches bar retroactive enforcement.
I understood, but the argument is not that they can't enforce their ordinances.
That's what the case law
Is that we
states,
have-
Mr.
that we allowed
Alexander.
on
If you
a
didn't read the
detrimental
case law and you relied on artificial intelligence to provide it to you, then that's your problem.
Excuse me, Your Honor?
You heard me. This is the Chat GPT motion.
Yes, of course.
And it cited the wrong cases in support of your argument. So don't come and tell the court I'm not using that case in support of my argument. That's precisely what you do when you cite a case.
Your Honor, I'm not being provided. I need more. I didn't know that I was going to be coming into here debating the case law within the motion. I was coming here.
What do you mean? You come in here prepared like any other lawyer.
Okay, Your Honor. Yes, sir. Yes, sir.
You come in here and you cite cases in your motion. You better be able to support the fact that those cases, in effect, support your argument. But that's not this. This case law is quite contrary to what it is you're trying to argue.
I would like to review that case. I'd like an opportunity.
You provided it to the court.
Yes, Your Honor.
And now you're telling me you got to review it? You didn't read the case law?
Yes, I did.
Well, then argue it.
Gosh, I'm not familiar with that case, that part of it.
Okay, let's move on, Mr. Alexander, because I don't have time for you to prepare for the argument here in court.
Yes, Your Honor. Then I concede. Then I'll actually concede. She's arguing that she has the right to said ordinance. I'm not arguing against that. I'm not arguing that let me be clear, please, Your Honor. I'm not arguing that she can't enforce an ordinance. I'm arguing that for 10 years, we relied on the state's own affirmation that we were, or that it was the normal way of doing business that they weren't doing. I've contended to you privately at the bench that I was assured in 2016, because we had another organization called the 17th Street Bar Owner Association, in which Mayor Ron Darling, John Ingram, and then Trevino, I believe it was Trevino
Mr. Alexander,
Rodriguez.
I'm going to stop
They
you
assured
because
us all
those
that-
are not legal arguments.
No.
Those are facts. You want to argue facts?
No, Your Honor.
If you want to argue facts, that's what the jury's for. All that you're telling me now, all those things you're saying that for 10 years or 16 years or however many years, you conducted business without any issues with the city, and suddenly something happened downtown and the city starts enforcing these restrictions, those are facts you can argue to a jury. But we're here for legal arguments only. Okay?
Yes, Your Honor.
That's why I'm telling you, when you cite a case, that's a legal argument.
Yes, Your Honor. Yes, Your Honor.
What else, Mr. Alexander?
I'd also like to argue that not really here. I'm not trying, okay. Sorry, I apologize, Your Honor. You used the word argue. So I kind of just repeated it.
I don't know what's left to take up. We addressed the issue of discovery.
I would like to
Address the issue of dismissal, which included the estoppel and latches. The longstanding cooperation with planning and zoning is a matter of facts, not of legal arguments.
I would say that at this point, and Your Honor, you can go either way with this, is that this court has the discretion, and it's your right to agree or not agree. But I think even the prosecution knows that we are in full compliance, that we were almost immediately, or that we were actively complying at the time we were brought in. And that in all fairness, that there really there's just not a government purpose in this because ordinances exist to get the compliance of those that are under them. And I would just at this point, the courts do have the discretion to determine whether or not there is a purpose in pursuing the case and going to trial.
Right.
And so while I'm sure you're fully aware of that, I thought that this might be the time to bring that up in this
Mr.
motion to
Alexander,
dismiss.
I'm going to tell you something. I think, and the court stands neutral and detached. I don't take any sides either way.
Understood.
But I think your arguments, not your legal arguments so much, but the facts that you're using to support your position are best presented to a jury because for all intents and purposes, you may have a legitimate basis with your facts. I'm just saying that a jury may agree with you arguing your facts. The issues with it's unfair, it's biased, it's prejudicial, it violates due process. Unfortunately, those arguments aren't viable because you've been provided with whatever it is you're arguing you weren't provided with. You may not have been provided with the things you wanted.
Understood.
But fortunately, in a court of law, if you weren't given whatever it is you wanted, then nobody can use it. So nobody can use it against you as well as you can't use it in the sense that you wanted to with your, how you had planned to use it anyway. And as far as being selective and arbitrary, that the city was being selective and arbitrary, you can make your arguments a fact. You can take the stand for yourself and make your own arguments to the jury. You can do that. And I'm just going to tell you that might be I'm not trying to guide you and tell you what to do, but I believe that might be your best approach to this entire trial. You can certainly make legal arguments, but at the end of the day, we've made the legal arguments we're going to make today. That's why we set it for pretrial. But everything you want to tell me outside the scope of legal argument are considered facts. Facts for a jury or for a judge if this were a bench trial. It's not a bench trial, it's a jury trial. So those things you want to tell me about, you've been in compliance with all these years, you remedied the situation, things of that nature. I think those are best argued to a jury so the jury can decide whether or not you have valid facts that could, for all intents and purposes, lean towards your arguments.
Yes, Your Honor. I mean, I apologize. I wrote these motions to dismiss 4 months ago, and I received the letter that this motion or this email would be happening just a few short days ago. And, just like yourself or anybody else, we're all very busy, and I apologize if we're not being able to answer directly on the case law. I had no fantasy that we were going to come in here. We were going to have a civil rights debate. I wasn't, I didn't think that's what was about to happen.
Was it a civil rights debate?
No.
This has nothing to do with civil rights.
Right. About due process and equal protection and punitive intent and those things. I didn't think that we were all going to go down that rabbit hole. I was right or wrong. I was hoping that the court might operate or exercise its discretion in noting that there was no government purpose for continued prosecution at this time, and that in all fairness, the purpose of the prosecution has been fulfilled. The ordinance has been fulfilled. And
you see those things you're telling me there right now?
Yes. You're talking about those
are things you should explain to a jury because they're not legal arguments. You see what I'm saying?
Understood.
But I think they may carry some weight with 6 people from the community that'll say, you know what? He's right. I mean, he fixed it already.
Your Honor, respectfully, the state is going to object to this line of discussion. It appears that, Mr. Alexander should not be guided into what arguments he should make to the jury or to the court in a pretrial hearing. He understood that his responsibility as a pro se defendant was to defend himself, as would an attorney. and I object to any further.
Understood, what I go in your objection so noted. But it's not the court telling Mr. Alexander what to present to a jury. It's telling Mr. Alexander the distinguishing factors between facts and law, and that those things he's telling the court are facts that need to be presented to a jury. And that there has been no legal argument made to support the motions that he's filed. And that's what I'm trying to get through to Mr. Alexander, that everything he's telling me that he wants to use to support his motions are not legal arguments. They are facts. And therefore, those facts need to be presented to a jury. And if those facts are something that the jury agrees with, then so be it. But at the end of the day, that's what the court is trying to explain, elaborate, and hopefully get through to Mr. Alexander so he understands why it is the court denied his motions, because he was arguing facts and not legal precedents or any type of legal argument to support his motions. So, anything else, Mr. Alexander?
I do apologize, and I know that I'm supposed to come here as a pro se defendant, but I'm not an active attorney, and I understand that. So what will be happening moving forward is I will be procuring counsel.
You don't have any more time. Trial's tomorrow.
Okay.
I mean, you can go get a lawyer.
The only problem is that has she, and I'm not trying to get you upset here. She talks about an email that was sent on December 23rd. I still contend I never received so email. Does she have a copy of the email that I can read? Because what I did receive from her and what I do have a copy was her objection to my discovery, which I responded to immediately. And was this sent by email only, or was it mailed? No, I did not receive this. It could have gone to spam or something like that, but I did not receive it.
Let's just make note for the record that the prosecutor has provided Mr. Alexander with a copy of the emails that were sent. They've been confirmed by Mr. Alexander that they were sent. They may have gone to a spam folder, but nonetheless, the prosecutor met its obligation to provide notice of discovery. Okay, anything else?
If, Your Honor, just as a point of clarity, if she made the attempt on December 23rd, but then also re-engaged on January 13th, and at that point submitted or at least presented me with a joint discovery statement, and at that point I made it clear to her that we had not concluded discovery, does that not bear weight and
just means you refuse to sign?
Means that, okay, well then I'm just trying to preserve for the record that I do not feel that the breadth of the discovery I had requested had
Again, that's already been
discovered.
addressed.
Yes, Your Honor. As far as the motions to dismiss.
They've been denied.
Yeah, denied. I'd just like to preserve my objection.
Mr. Alexander, there's a record of all this.
And I will be handed to you the first two pages. So only the first two pages are relevant. It doesn't matter if it's
Okay, I'm sorry.
Okay.
I'd
else,
like
Mr.
to
Alexander?
preserve for the record all,
There is a record on
all the
everything here,
arguments
so-
within my two motions to dismiss. I heard I'm just preserving. I'm just trying to do my best to preserve it.
Everything's on the record, Mr. Alexander.
Yes, Your Honor.
Anything else?
I guess I've been instructed if we couldn't, I'm not gonna lie, I kind of hoped we might move forward from this, but trial is set for tomorrow. It's not nefarious by nature. I am talking to counsel now, and I will be procuring counsel. That I would humbly like to ask for a continuance from that date, just enough time to bring in counsel.
Your Honor, I'm going to object to any request for continuance. I had a meeting with Mr. Alexander last year. I don't remember the exact date, but I can find it through email. He requested a meeting and indicated during that meeting that he was going to hire counsel. So he's had more than enough time.
I indicated that if we could not come to some sort of conclusion, that I would be sure to look for counsel. And I am now actively doing that. I actually have two different attorneys, both engaged in other cases at this time, that neither could be available today. They're both interested. it was an attorney, John Ball, and an attorney, Dennis Ramirez. They asked me at this time if I could please ask Your Honor for a continuance so that they could make themselves available for this court date.
We've had plenty of time, Mr. Alexander. There have been continuances granted throughout the entire process. So we'll be ready to go for trial tomorrow.
I was sure that this was the first continuance. Okay, but that's fine. Yeah, we'll see how this goes tomorrow.
And just for the record, this case started April 16th, 2025.
That,
this
not
is-
all three cause numbers started in
And this
April.
case has been reset 1, 2, 3, 4 times.
Just for
August the
clarity.
20th, 2025, it was set for trial, jury trial request. So since August the 20th, you've had time to obtain counsel, knowing that it was set for a jury trial already.
And
There
Your
are
Honor-
three cause numbers here, Your Honor,
Nonetheless,
and
you
two
were-
weren't even cited until September.
Your Honor, respectfully, the meeting
They
that.
were not in court.
The meeting that Mr. Alexander had requested took place on October 31st. At that time, the state made absolutely clear, in fact, Mr. Alexander very directly basically said, hey, if you don't dismiss my cases, I'm going to do A, B, and C. He did indicate during that time on October 31st that he was going to retain counsel. He has yet to do that. I don't think the day before our jury trial is the time to do that.
Could you clarify as to A, B, and C?
I believe during that time, and not that it's relevant, but during that time, you had stated that you were going to be reporting to the Ethics Commission and other actions that you were going to take.
I have filed a full complaint with the Texas Civil Rights Project, ACLU, Department of Justice.
Okay, those are not court
And
cases
so-
or matters that
so
are
I'm just
relevant to
letting
the
you
court
know
and the
that's full
trial.
transparency.
So, Mr. Alexander, anything else?
Before we got derailed there, yes. there
Anything else,
was.
Mr. Alexander?
Jesus, wait 1 second. I do want to make sure. I suppose we'll be seeing each other, tomorrow.